when you have Professor Dr. T.R. Subramanya, who's a Dean CMR University School of Legal Studies, Bengaluru, you know that you will understand the nuances of international law in a different perspective. And know that journey with Dr. Subramanian, the rights and the status of an individual in an international law, is today's topic, which we are going to take forward. And we welcome Sir back again. Over to you, sir.
Yeah. Namaste. Shri Vikas and your team. Today, I'll be speaking to you on the rights and status of the individual in international law. There was a poet, and this English poet once he said, individual is a part of the continent, and he is a lifeblood to the society. Without individuals, no society has existed. Perhaps no society could survive. This was a statement that was made long, long ago, about 500 years ago, by the great poet John Donne. Now, we carry forward this. What was the type of society that was prevalent, especially in the 16th, 17th, and 18th century? Now, in those days, remember, human rights or human protection was not given to the extent required or as we enjoy today. But even then, the concept was there in its origin. And there were scholars who spoke about the development of these rights. Now, instead of speaking about the French Revolution or the American Revolution, let me start with the divine despots. In the 16th and the 17th centuries, there were certain rulers who were called as the divine despots. Now, of the divine despots, Louis XIV happened to be a great ruler. And along with Louis XIV, there was Peter the Great of Prussia, Peter the Great of Russia, Catherine the Great of Russia, and Frederick the Great of Prussia happened to be the divine despots. And these divine despots, in their administration, said they were responsible, neither responsible to the people nor responsible to anybody. That means nor responsible to the Pope. Neither they are responsible to the people, nor they are responsible to the Pope, but then they are responsible only to the God alone. So in such situations, the basic human rights of the human being in a society, in a state was targeted. He was not given the minimum protection that was required. Now, if this was the story of the age of despots, we come to what we call as the era of the 19th century. When we come to the era of the 19th century, there appeared at least 2 or 3 important rights which are to be protected by the state. Now, when we take up this matter, you may ask me, which are these rights which are protected by the concerned state? One happened to be a movement against the institution of slavery. Slavery and slave trade flourished, remember, from ages till the Napoleonic age. It was in the year 1807 the state of Great Britain condemned the institution of slavery. Not only did it condemn the institution of slavery, but it said the institution of slavery as a practice will not be practiced by the state of Great Britain in her colonies. And that was the beginning of anti-slavery movements. But then at a later stage in the year 1813, as well as in the year 1815, after the defeat of Napoleon Bonaparte, all the allied victorious powers who participated in the Battle of Waterloo took a decision to see that in the French colonies as well as in the colonies of the other allied powers, slavery is not practiced. That is where the anti-movements and against slavery started, and today it has become a rule of law. Now, again, there was another right happened to be a right which is protect to the minorities. Now, there were several minority people living throughout the world, and especially in the Eastern Europe, there were many. And in the course of revolutions or wars, they were the target of attack. But then when we come to the 20th century, naturally, a movement began to protect and restore their rights. Now, today, minorities are respected all over the world, and it is being given protection under international conventions as well. Now, for example, there were as many as within the state of Soviet Russia. If you just look into and examine the Berlin Congress, there were as many as 41 minority treaties that were signed. This is only to protect the minorities. Now, under the present day international law, minorities have at least 3 to 4 rights. One right happened to be the right to have educational institutions. The second is the right to have charitable institutions, and the right to get money from the public fund of the concerned state for their development and welfare. Then the last one happened to be to protect their own language. Minorities are empowered to protect their own language, happen to be another major right that is being recognized under the constitutions of many states. Now, the third one happened to be humanitarian laws of warfare. Now, remember, when we speak about the humanitarian laws of warfare, there are plenty of statements that are being issued by eminent men. One such a person happened to be the great Will and Ariel Durant. Will and Ariel Durant is the man who wrote the 10 volumes on the story of civilization. Having written the 10 volumes on the story of civilization about the history of mankind, in the last volume, it is called as the epilogue. The epilogue is titled as the Lessons of History. In the Lessons of History, this great man points out, ever since Cain slew Abel, Cain as well as Abel happened to be the two persons, a boy and a girl born to the Adam and Eve. Ever since Cain slew Abel, war has been one of the constants of history. In the last 3,421 years of recorded history, only, remember, 268 have seen no wars. That means in every century, in every general tenure, remember, war has been one of the constants of history. Accursed be he who invented war. This is what, remember, William Shakespeare in Henry IV, one of his drama, is just points of, accursed be he who invented war. Remember, war, like gunpowder, only destroys. It cannot build. Now, in the Roman period itself, there were, in the Greek period, in the Roman period, as well as in the dark period between 6th to 16th century, there were some development. They said, irrespective of the cruelty that was practiced during the course of war, people who take shelter in the temples, people who are aged, people who are infirm with disabilities are to be protected, and expected mothers are not the subject of attack. Now, the very purpose of saying is, although it was practiced from ancient times, today it has become a rule of conventional law. And we have the Geneva Conventions on the law of warfare. The Geneva Convention of 1949, as well as the predecessor to this, there were several regulations which were adopted, the Hague Convention of 1907, the Hague Convention of 1999, then we have the Paris Convention of 1868. All of them, they spoke about the law or law of war, and they tried to humanize what we call as the war as a state policy. Now, these are the three major developments that took place. Now, when we speak about international law as well as the rights and status of the individual's international law, what I just wanted to tell you, in the course of the development of international law, the state sovereignty dominated the scene. When the state sovereignty dominated the scene, the states in international conferences were not prepared to give up anything. They would go to the extent of arguing what they say is right. This has to be accepted. And this cannot be, if someone says something against it, they will not tolerate. That was what we call as this concept of the state sovereignty. However, the state sovereignty was dominating the scene. At a later stage, what has happened was, in the course of the First World War, all the allied powers of the time, they joined together. Having joined together, they established what is called as the League of Nations. Now, the League of Nations came in under the principle of collective security. When I speak of collective security, remember, for the progress and development of humanity, for the progress and development of human civilization, for the progress of development of prosperity, what is required is international peace. International peace has to be restored and maintained, and come what may, it has to be. Now, in circumstances such as this, the League Council was established. Now, the League Council was given the power to maintain and enforce international peace and security. Now, the League has done wonderful work. You may ask me, what did the League do? Now, the League has done wonderful work. For example, it was the League of Nations which was responsible in signing the Treaty of Versailles, and after the Treaty of Versailles, the League of Nations came to be established. Then after the League came in, it was responsible in establishing what we call as a specialized agency to protect the working class. In the year 1922, the International Labour Organization came to be established. Today, remember this much, internationally and the international world, the International Labour Organization has been adopting conventions. All the conventions, when it is ratified by a state, it is binding on it. Now, this is for the purpose of securing what we call as the labor standards for everyone. It may be relating to working hours. It may be relating to pension. It may be relating to social security. It may be relating to collective bargaining. All of them since 1992 have been done by the International Labour Organization, and this is for the respect to the individual dignity of a human being in a society. Now, thereafterwards, in addition to this, for the League of Nations was the first one. It was in the year 1926. It called for the Permanent Slavery Commission. Slavery as an institution was condemned. You might be knowing the dictum of 10 Commandments. In the 10 Commandments, it is stated, God made men, but men made slaves. And if men made slaves, remember, there should be what we call as a freedom from these type of activities. That is why the League of Nations in the year 1926 itself constituted a convention, established a convention to prevent what we call as the practice of the institution of slavery. In 1931, it established a commission, permanent commission, to prevent the institution of slavery and put an end to it. So these are some of the things. I can speak hours together on this, but I just intend to give you and highlight certain basic objectives under the convention. Now then, although the League has done a wonderful thing, it died a natural death. It died a natural death because in the League of Nations, the United States was not a party to it. Since the United States was not a party to the League of Nations, remember, it is dominated by the state of France as well as the state of United Kingdom. When these states start dominating and dominated without hearing the words of wisdom from a powerful state like the United States, since it was not a party, there would be, there should be, and there could be, and bound to be quarrels and fights. And in the year 1938, it died its natural death. When it died its natural death, remember, for the protection of the human beings, as early as 1941, 1940 itself, Woodrow Wilson, as well as President Roosevelt, as well as the Prime Minister of the State of England, both of them, they met in a battleship in the Atlantic. Mr. Churchill, as well as Roosevelt, they met in a battleship in the Atlantic. And having met at the battleship in the Atlantic, they went to the extent of pointing out 4 rights are in danger today. And these 4 rights essentially are the rights of the individuals. And these rights of the individuals are to be protected, come what may. Then they said the first right happened to be freedom to worship God. Hitler had gone that far. Having gone that far, remember, he prevented the Jews in worshipping their gods. He annihilated them, terminated them. And in situations like this, they ran helter-skelter like a police chasing a thief. And they had to find some kind of refuge. Then came the protection of aliens as well as the rights of aliens in international law at a later stage. Now, in circumstances such as this, they said one right happened to be right to worship God, freedom of expression, freedom of thought and conscience. These are the rights which are in danger and which has to be protected. And the very next year, that is on January 6, 1941, they declared openly that they are the future United Nations. United Nations came in 1945. But on January 6th, 1941 itself, the world's greatest powers, who are called the Allied Victorious Powers, declared themselves they are the future United Nations. Then the deliberations took place for almost 4 years in different places. And these deliberations, when they have taken in different places, remember, it culminated what we call as a Dumbarton Oaks proposals. And after the number 10 proposals, then they had the conference. And at the conference, remember, San Francisco, they were able to adopt the Charter of United Nations, and it came into force on October 24th. Now, mainly, I just intend to highlight a few of the rights which are recognized exclusively for individuals. Now, when I speak of this, just think of the Charter of United Nations and its preamble. The preamble to the Charter of United Nations points out, we the peoples of the United Nations. Say, we the peoples of the United Nations. Remember, it not only speaks and not merely speaks for the states who have ratified the convention, but it speaks for the peoples of the world. Because these people have suffered twice in their generation from the scourge of war. One is between 1914 to 1918, and the second one is 1939 to 1945. And hence, the rights of the individuals are to be restored, come what may. We, the peoples of the United Nations. Then they said, protection of the rights of men and women, equal rights of men and women, nations large and small. Both, what does it mean? Equal rights of men and women are to be protected. Of nations large and small. For example, you have small states. You have a state known as the state of Nauru, whose, remember, area is just 7.25 square kilometers, but it is still a state in international law. The citizens' rights in these states, in the small states, in the petty states, remember, has to be protected. That is why it said of nations large and small. Then Article 1, paragraph 3 of the Charter of United Nations points out, remember, for violation of human rights based on race, sex, distinction of sex, and class is absolutely prohibited. So, any discrimination based on race, sex, and class of individuals, that is racial discrimination, is absolutely prohibited, as is expressed under Article 1 and paragraph 3. 1, paragraph 3. Now, in addition to this, we have some other things which is being stated in Article 2, paragraph 1. The Charter of the United Nations is based on sovereign equality of states. Maybe there may be big states like United States. There may be bigger states in area like the People's Republic of China and Canada. But then it is based on sovereign equality of states. And it is based on freedom, dignity, and worth of the person. That is being expressed in Article paragraph 2.1 to paragraph 2.7. All of them speak about this under the Charter of United Nations. Then we come to the other aspect. The Charter of United Nations speaks about the protection and promotion of human rights in Article 55 and 56. Article 55 of the Charter of United Nations is exclusively an article for the promotion and protection of human rights. And Article 56 of the Charter exclusively how it should be implemented. Now it simply says under Article 56, states are supposed to take joint and separate action for the protection and enforcement of human rights which are recognized under Article 55. Then it comes to Article 62. Under Article 62 of the Charter of United Nations, it is a right which is absolutely meant for the Economic and Social Council. Economic and Social Council is empowered to conduct studies. See, it may request the General Assembly to conduct a study on a particular subject. It may request the specialized agencies who are more than 160 in number to conduct specialized on research on certain important aspects relating to the economic and economic developments. Then under Article 68, the Economic and Social Council is empowered to have certain commissions. For example, the Commission on Narcotic Drugs. The Commission of Narcotic Drugs at the international level is done by the Economic and Social Council for the protection and promotion of individual rights. The citizens should be free. They should be free from drugs. They should be able to contribute to the growth of the society, the welfare of the society, which will be taken into consideration in toto by the international community. So, for example, there are commissions relating to the status of women. The commission relating to the status of women was established under the Economic and Social Council of the United Nations. Narcotic drugs commission came to be established under the Economic and Social Council. As students of law, you know all these developments which have taken place at the behest of the Economic and Social Council. Then you have one important article, which is 76C. Now, when I speak of 76C, it is relating to the population of the trust territory. Now, you may ask me, what is this population relating to the trust territory? Now, the people of the trust territory, I will speak with cases and illustrations so that you understand the point better. Now, the people who are not in a position to govern themselves, people who are not in a position to administer themselves, came under the trusteeship system of the United Nations. So when I speak about the trusteeship system, there will be a powerful state which is appointed as the administering state. And the administering state should go to the trust territory and should act as a trustee to look after the welfare of the other poor state. And it should be done under the supervision of the United Nations. See, the very purpose is whether you are in a position to administer or not. A powerful state, neighboring state may come and to help you, and you should protect and promote human rights. And ultimately, all of them should be in a position to enjoy promotion and protection of human rights at the international level. Now, you think of the other organizations as well. When I think of the other organizations, for example, think of the World Bank. Think of the International Monetary Fund. Think of the United Nations Conference on Trade and Development. Think of the United Nations Food and Agricultural Organization. Think about UNESCO. Now, all these institutions are established ultimately for the welfare of the individual. That is where John Donne said long ago, individual is a part of the continent. He is a part of the cake. His contribution should be recognized. His contribution should be respected. His contribution should be restored. That is why the Charter of the United Nations has done yeoman service from 1945 until this date. Now, with which I go to speak to you some of the important part. What I just wanted to say is the dominance of what we call as territorial sovereignty by states. Lord Braille, a great international law scholar, in one of his lectures at Oxford University, and the name of the lecture was Shortcomings in International Law. In his lecture on shortcomings in international law, or shortcomings of international law, he was the one who was arguing that at times certain powers assume sovereignty. These powers assume sovereignty more than what is required. They assume sovereignty for the simple reason because they have the economic wealth. And the economic wealth is a disturbance to the very concept of sovereignty. But then the United Nations try to ameliorate, try to condemn, try to eliminate what we call as the superiority of states under international law. I shall just tell you a few of the resolutions which are adopted by the General Assembly of the United Nations. And a few of the General Assembly resolutions, remember, were passed with voice vote. Now, one is a resolution which was adopted 1803. This resolution was permanent sovereignty over the natural resources. See, what has happened was most of the colonies became independent after 1945. After becoming independent, they became members of the international community. When they became members of the international community, colonialism had gone. But then, in the name of giving help, assistance, and other things, the colonial masters started visiting these states again for their natural resources. They thought that these countries are rich in natural resources, and these natural resources could be exploited by us again and again and again for perpetuity. It was at this juncture all the powers joined together, especially the powers from South Asia, powers from Middle East, the powers from Africa, and the powers from Latin America joined together. And they put pressure on the United Nations to adopt a resolution on permanent sovereignty over the natural resources. Now, when I speak about the permanent sovereignty of the natural resources, it said, remember, the sovereignty over the natural resources ultimately has to be exploited and explored, or explored and exploited by the concerned state itself. Under no circumstances, an outside state, United States or United Kingdom or Canada or other states can give advice to the exploration and exploitation of the natural resources of a particular state. This was one of the major resolutions that was adopted, and this was a slap on the developed states, which was adopted then in the year 1960. Now, the second resolution happened to be a resolution which was adopted in 1956 on self-determination. Now, it went to the extent of pointing out self-determination is a right of the peoples of the world. Suppose, for example, here is a state wherein the masters are dominating and exploiting and, remember, annihilating the resources for themselves. At this juncture, if they are a foreign ruler, the administrators of the foreign rulers, the concerned state has the sovereign right to say, we have the right to determine of an independent and sovereign government established by the people of their own. That is what is called as self-determination. So at a later stage, remember, self-determination became a human right. Now you may ask me, how you call it as human rights? Now in the 1966 International Covenant on Civil and Political Rights, and in the International Covenant on Economic, Social, and Cultural Rights, in the preamble, they make a mention. Self-determination is a basic human rights of all states. And ultimately, it is for the welfare of the people in the larger interest of the society and continent. This is how, remember, it became. Then, when we go for other important development, there are, for other important development, we have other conventions which are adopted as well. One is the new International Economic Order, which was adopted in 1974. The General Assembly adopted the new International Economic Order. And in the new International Economic Order, they went to the extent of pointing out exploitation of a state which is less developed or least developed is not allowed. Under no circumstances, it is very much essential that individuals in this country live with dignity. And they should express their freedom. And they should be facilitated, remember, for their freedom and welfare. This is what it said. Then we have what we call as the Convention on the Elimination of Racial Discrimination. See, it was in the year 1955, the Convention on the Elimination of Discrimination was adopted. Discrimination of all forms, racial discrimination or otherwise, is, remember, cannot be accepted by the international community. This is what the 1955 Convention on Elimination of Racial Discrimination went to the extent of pointing out. Now, you might be knowing the CEDAW Convention, Convention on the Elimination of Discrimination Against Women, 1979. Now, this convention also speaks with enough voice, musters enough confidence, saying that discrimination of any kind is absolutely prohibited. And if it is done, remember, it will go before the committee which is being put up and established under the Convention on the Elimination of Discrimination Against Women. Then you have other convention, Rights of the Child, which was adopted in 1979. The children, remember, they are the future citizens of tomorrow. And they should be brought up with individual dignity. They should be able to cherish their desires. What is nourished by them at a young age must be allowed to be facilitated by way of cherishment at a later stage. This is what is being pointed out in the Convention on the Elimination of Discrimination of 1979. In all these circumstances, remember, the United Nations has done wonderful work. Now, for example, I can just speak to you at a later stage, the right to extradition, the right to asylum. Now, these are all ultimately part of the concept of human rights in international law, that is to facilitate the individual dignity and honor. Now, thereafter, we come to a few of what we call as the cases which are decided by the International Court. Now, unless we explain a few of the cases, we will not be able to understand the concept very clearly. One case that came up before the the Permanent Court of International Justice happened to be the Danzig railway officials case. Now, the Danzig railway officials case, listen to the facts of this case. Remember, Danzig city happened to be a city which is situated near the state of Poland. And this city, situated by the state of Poland, remember, was carrying on its activities very well. In the year 1921, in the month of October 1921, the state of Poland, as well as the free city of Danzig, entered into an agreement. And under the agreement, remember, it is certain rights that is being extended to the free city of Danzig, that is to the railway employees of the free city of Danzig. So under the agreement of October 21st, 1921, certain rights were granted by the state of Poland to the free city of Danzig, especially to the railway employees of the free city of Danzig. Now, what has happened was, after 2-3 years, the entire free city of Danzig merged with the state of Poland. When it merged with the state of Poland, it became the free city of Danzig became part of the state of Poland. When it became part of the state of Poland, remember, the railway officials of the free city of Danzig wanted to enforce their rights. When they wanted to enforce their claim, enforce their rights, the matter was taken up at the higher level, at the government level. The Polish government, having heard the claim of the Danzig free city state, which has become part of Poland, pointed out, remember, this rights was earlier in force, and this was given under an international treaty. What was recognized under an international treaty, remember, which has not yet become part of the Polish law, what was recognized by way of a bilateral treaty between Free City of Danzig as well as the other state, the state of Poland, has not become part of municipal law, the state law of the state of Poland. Since it has not become part of the state of Poland, Polish law, we cannot restore your rights. Then the other thing important they pointed out, first and foremost, remember, the intention of the parties, it cannot be recognized here because it is not part of Polish municipal law. Now, at this juncture, the railway officials represented by the Free City of Danzig go to the Permanent Court of International Justice. Before the Permanent Court of International Justice, the state of Poland pointed out the earlier agreement of 1921 is only an international agreement. In an international agreement, the individuals have no locus standi. Individuals have no locus standi at all. They cannot enforce the right. This was an agreement entered between the Free City of Danzig and the state of Poland, and they cannot enforce their rights. Moreover, it has not become part and parcel of the Polish municipal law. Now, the International Court of Justice, having heard the argument, first and foremost asked a question to the city of Poland, state of Poland. It said, for what purpose the agreement was signed? The intention of signing the agreement was to restore the service conditions to the railway employees. Since the intention of the agreement was to restore the service condition of employees, it is the duty of the state of Poland to restore these, remember, service conditions even after it merged with the state of Poland. That was perhaps the first case. In 1928, when the decision was given by the Permanent Court of International Justice, it was hailed, it was appreciated, it was applauded by everyone, saying that individuals have become the subjects of international law. Now, the next stage which I just intend to speak to you happened to be the Nuremberg trial. Now, in the Nuremberg trial, I shall briefly describe the facts of the case. See, during the course of the Second World War, there were two sides. One is the Axis side, which was represented by the state of Italy, Germany, and Japan. The other one happened to be the Allied powers. The Allied powers were represented by the state of United Kingdom, the state of Soviet Russia, the state of France, the state of United States. These are the four states were called the Allied victorious powers. Germany, during the course of war, was committing inhuman atrocities. It was committing murder, extermination, enslavement, deportation, and genocide. And when it was committing murder, deportation, and genocide, and other things, the Allied victorious powers warned the state of Germany. please don't commit international crimes. Don't commit genocide and deportation. And if you commit this, soon after the war, you will be booked and you will be tried. But Germany did not bother, and the war came to an end. And soon after the conclusion of the war, the Nuremberg trial was constituted. When the Nuremberg trial was constituted, remember, the hearing began in Germany at Nuremberg. Nuremberg happened to be the place of a peace palace in Nuremberg. Now there the trial started beginning, and when when the trial started hearing the cases, the four important developments have taken place. There were one allied victorious powers, and the second one, the other one important happened to be the Axis powers. The state of Germany pointed out the whole trial is constituted by one side of the war. When I speak about the whole trial is constituted by one side of the war, it said, remember, the whole trial is ultimately constituted by the victorious allied powers like United Kingdom, then Soviet Russia, United States, and France. And we cannot accept it. Then they said that the trial is hearing the cases under ex post law. Now, what is this ex post facto law? When I speak about ex post facto law is, see, when the Germans committed the crime, it was not a punishable offense. And after the conclusion of the war, you made it a punishable offense. Murder, extermination, enslavement, deportation, and genocide were made punishable offenses after the commission of the crime. This cannot be accepted. Then similar crimes were committed even by the allied victorious powers. When Germans were committing crimes, you mean the allied victorious powers were doing bhajans? They were also doing the same crime. They also were responsible in committing murder, extermination, deportation, and genocide. But then the Nuremberg trial rejected such arguments. Having rejected such argument, it said, crimes against international law are committed by men. Listen. Crimes against international law are committed by men. And only by punishing these men can the provisions of international law be enforced. And Nuremberg tribunal did not exercise jurisdiction over Germany. The Nuremberg tribunal exercised jurisdiction over certain German nationals accused of international crimes. This is what the Nuremberg trial pointed out. This is a victory for the individual. Victory, remember, for the states who commit war crimes and they were punished. You may be knowing now, today you have what we call as the 2003, you have the International Criminal Court, which is being set up at The Hague. There are several cases which came in. And in these cases, those who are responsible in perpetrating inhuman atrocities like murder, extermination, and genocide, all of them are brought to book. And it is a success story for the rights of the individual here as well. Now, the third case happened to be a case which I just intend to bring home. Very much essential. There are 2 or 3 cases which I just wanted to harp upon. One case happened to be the reparation case. Now, you may be interested to know what exactly is the reparation case and its facts. Now, the reparation cases, see, in 1945 and 1946, the United Nations, when it came into force, wanted to send several of its employees to various parts of the world. And they wanted to send several of the United Nations employees for the suppression of hostilities. For the suppression of hostilities, that is, they were going as truce negotiators to suspend the hostilities. Now, what has happened was there was a person from Sweden, Colonel Bernadotte. Colonel Bernadotte, a Swedish national, was sent to the state of the new city of Jerusalem for the suppression of hostilities. When he was sent to the new city of Jerusalem for the suppression of hostilities, he was killed by a gang of terrorists. See? He was a United Nations employee, a man who was on a higher rank. He was appointed by the United Nations. And he goes on a particular mission assigned to him by the United Nations. During the course of his service, he was assassinated by a gang of terrorists. Now, immediately the question came, can the United Nations, as its employer, is entitled to maintain an action against such irresponsible state and entitled to claim compensation to the United Nations? entitled to claim compensation to its employee who lost his life, and compensation to the what we call as the survivors of the family. Now the matter, when they were not able to come to a conclusion, the matter was referred to the International Court of Justice. When the matter was referred to the International Court of Justice for an advisory opinion, the International Court of Justice pointed out, first and foremost, 50 states then established collectively a treaty. Under the treaty, they have said we are prepared to respect the provisions of the treaty, and accordingly, the Secretary General has appointed certain people, and these people who are appointed by the Secretary General go to the spot to suppress the hostilities. And during the course of employment and during the course of service, the concerned person, captain, was killed. And if he is killed, naturally, remember, the United Nations, as the employer, is entitled to, remember, represent his claim. And it is entitled to represent the claim of his state, home state as well, Sweden. And in all cases, it is just. During the course of the argument, the International Court of Justice pointed out, United Nations has a personality of its own. If it has a personality of its own, it could sue as well as be sued in its own name. And even, remember, there will be a preference between his home state as well as the United Nations. United Nations must be given first preference because he was employed as a national. For the first time in the history of international law, United Nations employees were decided by the ICJ as the subjects of international law. Now, another case happened to be a case which is known as the effect of awards to the administrative tribunal. In the effect of the awards of the administrative tribunal case, you may be interested to know what exactly are the facts. See, for example, the Secretary General of the United Nations issues orders, and it is the Secretary General who employs all United Nations employees. And when the United Nations employees are employed by the Secretary General of the United Nations, if he issues the order, if he has the power to issue the order of employment, he has the power to terminate and suspend them from service as well. If they violate, see, most important thing is if you go to the service conditions, first one is they care for efficiency. And efficiency is given the topmost priority, and only such people are taken into the United Nations from various countries. And they are not supposed to disclose information. Secrecy has to be maintained. In the event of a disclosure of information, remember, naturally, they will be terminated from service. What had happened was 16 of the United Nations employees were serving in some parts of the world. When they were serving in some parts of the world, most of them were American nationals. These American nationals, who are United Nations employees, during the course of service of employment, they leaked out certain information. And it was against the professional conduct. And the United Nations Secretary General wanted to initiate action against them. And remember, immediately the American government said, we will appoint a federal grand jury. Since they are our nationals, we'll appoint a federal grand jury. And it appointed a federal grand jury, and they wanted to try at the American level itself. But then these employees refused to attend there and give evidence to this. They refused to go there and give evidence for the one reason, because under the existing rules of law, general law, no person can be a witness against himself. No person can be a witness against himself. And they said, we will not go there and give evidence. When the file went to the Secretary General, he suspended a few of them. He dismissed a few of them. He restored the services, a few of them. Remember, when you dismiss and suspend the services, there will be, naturally, you have to pay compensation. And the compensation that was awarded came into nearly $1,709 $709 million. And this has to be given by, approved by the General Assembly. Now, the compensation that was awarded by the Administrative Tribunal goes to the General Assembly for approval in its budget. When it goes before the General Assembly for approval in its budget, the United Nations General Assembly said, who is this Administrative Tribunal? Remember, Administrative Tribunal is employed by us. We are the one who constituted the administrative tribunal. How can they direct us to award compensation to the employees of the United Nations? We are the ones who employ. We are the ones who terminate. We are the ones who terminate. Who is this administrative tribunal? Now, when there was no compromise, the matter was referred to the International Court of Justice. Now, when the matter was referred to the International Court of Justice, now there was only one major question. Can the General Assembly of the United Nations refuse to accept the decision of the administrative tribunal? Simple question. Can the General Assembly of the United Nations refuse to accept the decision awarded by the administrative tribunal of the United Nations? Now, when it went there, the International Court of Justice heard the argument. When it heard the argument, it asked the International Court of Justice to get the Travax preparatories. When the United Nations was formed, there were a lot of discussion that went on. In the discussion that went on, they said, administrative tribunal is a tribunal which should act as a judicial body. And this judicial body, it should be, remember, is under the mercy of anybody. And it should be there to maintain the efficiency and competence of the United Nations employees. In order to enforce the competency and efficiency of the United Nations employees, it should function. Then, since it is a judicial body, its judgment, remember, has to be respected by the General Assembly. The point is they said, for this purpose it is appointed, and it is a judicial body, and its decision has to be respected by everyone, come what may. Now, then it said, a decision of the administrative tribunal is res judicata. Remember, it is res judicata. It cannot be open up for hearing. And what is awarded by the administrative tribunal must be, remember, accepted by the General Assembly. For the first time in the history of international law, I just want to tell you, United Nations employees became subjects of international law. See, there are several treaties that are signed today. And in these treaties, most of them are commercial treaties. For example, take it this way. Now, treaties under the investment, promotion and protection of investments. Lots of states. Why lots of states? All states will have, remember, treaties on promotion and protection of investments. Now, when I speak about promotion and protection of investment, remember, in the name of investments, it is not the individuals, it is the big companies. From India, for example, the Tatas, the Rusis, the Birlas, the Mafatlals, and all of them, they go to a foreign country and make investment. And when they make investment, remember, they enter into a treaty with that state, with the host state, saying that in the event of a dispute, the matter shall be referred to the Paris Chamber of Commerce. You must have heard, as law students, you must be knowing all of them. So they go there and settle the dispute once and once for all. So here also, corporations are as well as individuals are recognized as subjects of international law. And you cannot just, remember, do away with that. Now, most of the international treaties, because under the present day international law, almost after the coming into force of the WTO, globalization has set in. The liberalization is operating. Most of the multinationals go and invest money. They want to develop. And in the name of development, they make money. At that time, naturally, the receiving state has to protect them. And this is done through international treaties and international conventions. Now, thereafterwards, I just wanted to speak to you. Now, what was decided by the International Court of Justice, remember, has been practiced in the regional level as well. Now, you may be interested to know, unless I explain this at the regional level, the discussion is totally incomplete. Now, what exactly you mean by the discussion at the regional level? For example, at the European level, you have what we call as the Council of Europe. There was a great statesman, and this great statesman was alive during between 1900 to 1935. And he was called as Mr. Briand. Mr. Briand happened to be a French statesman. This French statesman was mainly responsible in the integration of European states. Initially, there were 7 states they came together. After the 7, it became 17. And today, you have as many as 46 nations who have come together under one umbrella. Now they say integration of Europe ultimately for the economic development of everyone. There should be peace, progress, and prosperity in all the European states. Now, for example, a particular state is very weak in producing a particular raw material. If a state is weak in producing a particular raw material, the other state which produces more will be in a position to operate and send these raw materials to, remember, fill in the deficiency for this purpose. That is where, for example, they have a common market. And under the name of the common market, remember, all goods can flow freely from one state to another in the European state. You know, one visa, if you take, remember, you can go to visit 16 countries minimum. Like that, goods from one European country go to the other state. Then it is not common market, it is EFTA, European Free Trade Area. Under the European Free Trade Area, all goods produced by the European countries can go to each of them, and each of them is empowered by it, wherein it actually restores the individual freedom or the right to, remember, have business in any country in the world. Now, thereafterwards, the other one is a common agricultural system, common transportation system, all of them, then common atomic energy, and the present day to reduce what we call as the global warming. They have a common cause of action. This is ultimately to protect the individual. That is why man is part of the continent and he is a subject. And this subject is part of the cake and you cannot spoil him. You should restore this right. Whenever they think of the entire European people. To protect the entire European people, they will have rights and obligations. And they have entered into a treaty which is known as the European Convention of Human Rights of 1950. Now, you may be interested to know, and you should know also, under the European Convention of Human Rights, who can be parties. See, for example, under the European Convention of Human Rights, they have defined certain human rights. Freedom from torture, freedom from inhuman and degrading treatment, freedom of the press, freedom of movement, right to property, right to asylum, right to nationality. All of them are being spoken. All of them are maintained in the Universal Declaration of Human Rights as well. Now, the point at issue is right to inheritance. All of them are being spoken. Now, the point is, under the European Convention of Human Rights, one European state which is a party to the European Convention can bring an action against another state. Suppose, for example, if the state of Belgium violates certain basic human rights under the European Convention of Human Rights, the state of Netherlands or Holland can bring an action against the state of Belgium. If the state of Holland violates a particular provision of the European Convention of Human Rights, the state of France can bring an action. The state of Portugal can bring an action against the state of France. That is what I'm saying. One member can bring action against another member for the violation of the human rights that are stipulated under the European Convention of Human Rights. The second one happened to be an individual of a particular state. Suppose you are a French national or a German national. If your human rights are violated by your own government, you can bring an action against the supranational body, that is the European Commission of Human Rights. From there, it can go up to the European Court of Human Rights. See, you can complain, bring an action against your own government for the violation of the rights recognized under the European Convention of Human Rights. That is such a great thing. Now, the third important is important for all of us. For example, you visit as a visitor to any individual, an outsider who has nothing to do with the European states. When during the course of your visit, if your rights are violated under the European Convention, at that time, you can make an appeal before the European Commission of Human Rights. From there, the matter can even go appealed to the European Court of Human Rights. Suppose, for example, you go in a scholarship to a European country, to Germany, to France, or to Netherlands, or anywhere. At that time, your basic rights recognized under the European Convention of Human Rights are violated. If they are violated, you can bring an action during your stay. That's all. When you leave, you will not get the opportunity. You can bring an action. So this is, remember, a supranational convention, international convention, wherein rights are restored. I just intend to speak to you only two cases, so that this is done to understand the point better. One happened to be the Sunday Times case. Now, the Sunday Times case is, remember, Sunday Times is a newspaper published from London, and editor of it is Harold Evans. Now, what has happened was there was a company which is known as the Distillers Manufacturing Company. This Distillers Manufacturing Company was producing a capsule. And this capsule produced in Germany was administered to expectant mothers. And this company ultimately had its office in London. And this medicine, it is called as the thalidomide medicine, was administered to expectant mothers in England. As it was, remember, it was a prescriptive drug, and as a prescriptive drug, it was administered to many people, and thousands of people, remember, took this, and at least 450 of them, expectant mothers, when they gave birth to deformed children. 450 of the expectant mothers, when the thalidomide capsule was taken, gave birth to deformed children. Now, Lord Evans, he was the last man to keep quiet and quietly quiet. He wrote an article saying that how the thalidomide incident has taken place. How exactly the origins and the subsequent development, and the 450 cases which have conducted, and the deformed children and their fate. And in the last line, they said, we will be publishing in our next article how the horror has taken place. See, the next article will describe how the horror had taken place. Now the state of England got surprised, and remember, they were worried because England, it is not India. England is not India. Public opinion was so much there. I can just tell you the kind of public opinion in the state of England. See, during the course of the war, every necessary items and eatables were distributed through the what we call as ration. And you have to go and stand in the queue and take your rations every week. And at that time, remember, the Battle of Bulge and the Battle of London has taken place. When the Battle of London and the Battle of Bulge has taken place, there was an announcement over the BBC. BBC just said, there is shortage of food. Especially the soldiers don't have enough stock. We request the citizens of the state of Great Britain to return at least half of it so that the soldiers survive. The previous week, they were standing in the queue to take the ration. And the next week, after the announcement, they were standing in the queue, in the same queue, perhaps, remember, to return the ration for the survival of soldiers. So when this came, how the tragedy occurred will be revealed to you in the next article. They were taken aback and immediately served the Attorney General. And they requested the Attorney General to serve a stay. And the matter goes to the lower court, the High Court there. Then it goes to the Court of Appeal. Then it goes to the House of Lords. And in the House of Lords, in the Court of Appeal, and in the other High Court, remember, the contention of the administration was accepted, and it was not allowed to publish the article. But Harold Evans was the last man to keep quietly quiet. He goes to the European Commission of Human Rights. Having gone before the European Convention of Human Rights, he says, this is a clear violation of Article 10 of the European Convention of Human Rights. Article 10 of the European Convention of Human Rights clearly points out press freedom is all the more required. Public opinion is generated through the press. And here is a case wherein public opinion is put to an end by the administration. We are not allowed to publish the article. And European Commission of Human Rights said his petition is admissible. And remember, when it was done, the state of England had to go and negotiate. And the matter, the British administration refused to negotiate. The matter goes to the Court of Human Rights, because European Commission of Human Rights is a negotiating body. When it refused to be negotiated, the matter goes to the European Court of Human Rights, and the European Court of Human Rights issued summons to the United Kingdom. And it was at that time the state of England said, we will alter the law. We will alter the law in accordance with Article 10 of the European Convention of Human Rights, and we will restore press freedom. This is what has happened in the Sunday Times case. This is one case. Now, the another case is a short case. There are millions of cases. I am just giving you, because of the paucity of time, only two cases. Paula Marx versus Alexandria Marx. Now, Paula Marx happened to be a mother, and she was from the state of Holland. No, she was from the state of Belgium. Now, she had a daughter, and her name was Alexandria Marx. Under the Belgian law, under the Belgian civil code, remember, a lady who marries a person, this is what is called as, remember, not within the institution of marriage, outside the anybody, and having, remember, illegitimate marriage. This is called as illegitimate marriage. She marries a person, and under this illegitimacy, Alexandria Marx was born. Now, the question is, an illegitimate child born to Paula Marx, under the Belgian civil code, is not entitled to claim equal property that of the really wedded born child. And this has to be corrected. So an illegitimate should also get equal proportion of the share under the, as per the Convention of Human Rights. And the court, having heard, they said it is right and it has to be accepted. This is what the court has pointed out. Now, we have plenty of cases, wonderful cases. Now, one session is required only to know about these cases. Then we have another important case, which I just intend to speak to you about, individual dignity. And that case happened to be the Southwest Africa cases. Now, you may be interested to know what exactly you find in the Southwest Africa cases. I shall just give you the prehistory and the present status. Now, under the League of Nations, under Article 22 of the Treaty of Versailles, under Article 22 of the Treaty of Versailles, the League of Nations, remember, constituted what we call as the mandate system of the United Nations, League of Nations. Mandate system of the League of Nations. Now, what do you mean by mandate system of the League of Nations? Now, under the mandate system of the League of Nations, it created a mandatory and a mandated state. Now, a state which is not in a position to govern itself, a state which has the very weak administering capacity, could come under the mandate system of the League of Nations. Now, it will be considered as a mandated state, and there will be a mandatory. That means what? A powerful state, a civilized state, could come under the supervising capacity. The League of Nations will appoint a particular state as the supervising state. And this supervision of the mandated state should take place in accordance with the principle of international law. It should take place in accordance with the principle of the League of Nations. It should take place in accordance with the conventions on the protection and the promotion of human rights. And ultimately, all the people should be independent in the mandated area. And they should be in a position to hoist the flag of independence. So that was the purpose. Now, what has happened was, Namibia, remember, was the poorest state at that time. And when Namibia was the poorest state at that time, remember, South Africa was appointed as the mandated state. Now, South Africa was appointed as the mandated state to look after the administration of Namibia and submit reports annually of the work it has done to promote the welfare of the Namibians to the League of Nations. Now, it was going on. South Africa used to submit reports about its activities in Namibia, what it has done to improve the welfare, how many schools are being established, what type of education is imparted, what type of improvement in the economic conditions have brought out, everything it was reporting to the League of Nations. Now, what has happened was, in the year 1939, the League died a natural death. When the League died a natural death, remember, the reporting system came to a grand halt. because there was no international institution at all. And till 1945, there was no institution, and in 1945, they established what we call as the Charter of United Nations. Professor Bhavet, one of the eminent authorities in international law, points out the failure of the League of Nations to restore international peace and security did not destroy the convention shared by many, that only by way of establishing an international institution could international peace and security be restored. This is what he says. I'm just verbatim, I quoted it. Now, in situations like this, United Nations came in. Under the United Nations, we have a chapter known as what we call as the Trusteeship Council. Under Chapter 12 of the Charter of United Nations, you have the Trusteeship Council. Now, the Trusteeship Council of Chapter 12 is very similar to the chapter on mandatory system of the League of Nations. Now, it said states who are not in a position to administer, these states who are very poor, these states who are underdeveloped and ill-equipped can come under the assistance of a powerful state. And this powerful state, remember, its activities will be supervised by the United Nations. Now, what has happened was when the United Nations came in, first 2 years, the state of South Africa submitted reports about Namibia. And the first 2 years is submitted, and at times he never replied also. And afterwards, what has happened was it refused to submit to the jurisdiction of United Nations. When it refused to submit, remember, to the supervision of United Nations, the matter was discussed in the General Assembly. And the General Assembly prepared 3 questions. And these questions, 3 questions, were requested to be delivered by way of a judgment by the International Court of Justice. Now, you may ask me, what exactly are the 3 questions? Now, the first one is whether Chapter 12 of the Charter of United Nations is applicable to the present case. Chapter 12 of the Charter of United Nations relates to the trust territory, whether it is applicable to the present case. The second is, can South Africa alone alter the status of the territory? Whether South Africa alone can alter the status territory was the second question. If it cannot, who could? Now, these are 2 or 3 questions which were posed to the International Court of Justice. Now, the International Court of Justice just pointed out, when an organization has established certain things for the betterment and welfare and to improve the living conditions, economic and political conditions of the people through a mandatory, and when it was functioning effectively, and when that organization becomes defunct, defunct means, dictionary meaning is, it has finished the course of life. Another organization established for a similar purpose can take up the responsibility. That means what? The Trusteeship Council of the United Nations is empowered to exercise the powers which were earlier given to the mandate system. Now, under Chapter 12, the trusteeship system is empowered to appoint commissions. The commissions employed directly can go to Namibia, and South Africa should submit its annual report, what it has done, how improvement is taking place in the concerned area, that is in Namibia, and it has to be supervised. But then, when it did not do, after the judgment also, after the 1950 judgment it came in, it did not do. The matter was referred to the ICJ again in 1961. And the judgment was delivered in 1966, but still South Africa was carrying on its apartheid policies in Namibia. But then the last judgment came in the year 1970. In the year 1970, the International Court of Justice delivered its judgment. And it said, I shall quote the judgment, the very presence of South Africa in Southwest Africa is illegal. The very presence of South Africa in Southwest Africa, that is in Namibia, is illegal. Remember, South Africa should end its colonialism and apartheid policies in all its forms and manifestations. South Africa should facilitate self-determination. And ultimately, the people of Namibia are sovereign. And they should be in a position to hoist the flag of revolt to a government, against a government which is not in their favor. And they should facilitate independence by choosing a government of their choice. That is true to self-determination. That is where Namibia became independent, and the state of India also has, remember, helped in a long way. Now, what I just wanted to tell you is what is being done at the European level is being done at the Latin American level as well. And we have what we call as the Latin American Commission of Human Rights, Latin American Court of Human Rights. You have more than 30 Latin American states. They also have come together. Now, these are certain illustrations which I just wanted to give you. And in addition to this, we have an Arab Commission of Human Rights. But in the Arabian theater, all the Arabs also have joined together. They don't have a court of human rights. And with this, ultimately, individual rights are protected and enforced. Now, one important aspect which I just wanted to tell, see, ultimately, civilization transcends states. But remember, individuals transcends beyond state. And ultimately, for the welfare of individuals, every society exists. And the development, remember, the articles written by positivists, the articles written by naturalists, and the articles written recently by scholars of international law, ultimately go to the extent of pointing out individual is the end of all laws. All laws are made by, remember, by a state for the people and for the welfare of the concerned state. It is made by the people, for their people, and for the welfare of their people. This is where individual dignity is restored. Thank you once again.
Yes,
Yeah.
sir.
Yeah. Any
So as
questions?
usual, I always feel that whenever you are on the platform, you all get enlightened. There already one comment has come. Erudite lecture, sir.
Thank you.
Thank you, everyone. Stay safe, stay blessed. Namaskar.
Thank you. This is all. There was a lot of irritation to join there, but in spite of it, I gave the best.
Yeah.